Welcome to the first crossover episode of Genuine Questions and the SOL podcast. So for those who watch me on the Genuine Questions channel, I am also on a podcast called the SOL podcast, where I go by the name Special K with my co-host Shake and Bake and the Iron Man. And we like to talk about things going on in the news and current events, but talk about them from a legal perspective. And for those who are listening in from the SOL podcast, I also have my own solo venture here called Genuine Questions, where I like to talk about things going on in the news and history from a little bit different perspective than what the mainstream media tells you is going on. Some might call it a conspiracy theory channel, but I like to think of it as a haven for inquiring minds who don't trust the crap they're being told by the media these days. I'm going to be sitting first chair. I'm the host today, which is why we're doing this one social distance, because I heard that there's a new mega Omicron variant coming out, and I always take an abundance of caution with the COVID rules. So we're doing this one socially distanced today.
Excuse me, I farted.
Yeah, obviously psych on that, but this is, since I am in charge today, I will mute you guys if you start trying to say nice stuff about Bill Gates or whatever. I know Matt loves to talk about how much he loves Microsoft all the time, and we're not having any of that today. So I will go Papa Bear O'Reilly and cut your mics off. Thank you, Drew.
I'm just a fanboy. I can't help it.
Just
Yeah,
one?
I feel like safe for now. I was worried.
Just one or?
That's two. I've got one behind this one, obviously. Okay.
Thank
Oh, they
you.
lifted the mask mandate. Oh, good. Okay.
Right here.
Oh, wait, no, they're putting it back on. Okay, all right, it's gone again.
In all seriousness, we're doing the show this way today since Drew had to flee the state. So we have to do this remotely now because we didn't want to skip a week. There's a lot of interesting court cases going on, and we want to talk about them. So let's start with the local one. How do you pronounce the Mount Carmel doctor's name? Husel?
William Husel.
So he was charged with murder. He was overdosing patients with fentanyl, and the way the news was reporting it at the time, well, yeah, allegedly, because he was just found not guilty. But the way the news was reporting it, and you got to take that with a grain of salt because the dispatch isn't always reliable. But they were saying he was giving them lethal doses of fentanyl, and his defense was that it was comfort care. Is the end of life, but some of those families said their relatives would have recovered, and he just murdered them. So I admittedly did not watch much of the trial footage, so I don't know exactly how strong their evidence was, but the defense attorney that got him off is actually the same guy that represented Casey Anthony. So, sometimes crazy things do happen.
I didn't watch much of the trial either, but one thing I found to be incredibly interesting about the defense approach is they called a total number of witnesses to the tally of one. So they had one witness testify, and then they rested their case. I can only assume that witness testified that the standard of care in the medical field was not breached, or it was within the parameters of the standard of care to administer the amount of fentanyl in which he was administering to critically ill, end-of-life patients. So, interesting approach. I'd like to know more about that.
You think if they would have gone for lesser charges, they would have been able to?
Well, that's a whole other topic, yeah. Well, I think a lot of people were confused as to how could it be a not guilty verdict, probably because a lot of the press and the attention it got in the press had to do with, he was doing this well beyond what would be acceptable within the medical field. Obviously, we all know there's hospice care and other types of end-of-life care that involves heavy narcotics to cope and deal with the pain. I don't know what the standard is. What I do know is that, this particular doctor seemed to have a history of helping patients with this issue in terms of turning it into somehow you went outside boundaries of the civil medical standard of care and you breach that, when you look at the criminal side of it, that he was charged with murder. And murder requires one element that is always going to be difficult in dealing with a doctor. A doctor, just by nature of what they do, is save lives, not take lives. I think there's an underlying theme with doctors, a bit of a God complex, whether they have it or not. I think the general public feels that doctors in many ways are saviors, and they are, and they've studied and they research and they do things that certainly help a lot of us when we're sick. But it's almost like we can't make the jump or the leap that a doctor would ever do anything intentionally wrong, let alone wrong in general. I mean, in civil cases, med mal cases, very difficult cases to win because the general public doesn't see doctors that way, of making mistakes, where if they do, it's so unintentional and they kind of weight it against all the good things and all the great things they've done in their career, saving other people's lives. So when they charged murder at the criminal level, there was a whole other element that had to be proved, and that was the intent element. But there was an intent here, a mens rea, otherwise known as like the mental aspect. There was an intent for this doctor to kill the patients in which he administered high doses of fentanyl to. And I just don't understand why the prosecutor would ever gone that far with something like that, because in reality, anybody that does trial work knows in the civil realm, it's hard enough just to get a jury to say they made a mistake and we're going to hit them for it. To get to that next step and make that next jump of not only did they make the mistake, but they did it intentionally to take the life of another, I just think that was way overcharged. Maybe a more appropriate charge would have been something like what we call a negligent homicide, which is akin to me driving down the road. There's a runner on the road. I absolutely don't see the runner, even if I am distracted and I'm doing something I should be paying more attention. I hit the runner and it kills them. I didn't mean to kill the person. I didn't have the intent to strike them with my car and kill them. Did I kill them? Yes. Was it something that was awful and I didn't mean to do? Yes. But did I ever at any point look at that runner and say, I'm going to hit them with my car and kill them? No, of course not. So because of that, that's kind of the same situation here, as you're saying that when he was administering the doses, his mens rea, or in his head, he was thinking, I'm going to try to kill this person. So negligent homicide may have been a more successful charge for the prosecution in terms of getting a guilty verdict.
That makes sense. And like, I don't think he testified in his own defense too, so it'd be hard to prove his mental state if he's not talking. So.
Well, I think so if you look at the testimony, I know Shake and Bake mentioned perhaps his testimony had to do with standard of care. And in fact, the defense's only witness testified as to the cause of death for these 14 patients. And essentially,
is that what it was?
Yeah, essentially said
okay.
Their underlying medical condition is what killed them.
Yeah.
Now, that may not have been what the jury used at the end of the day to make their decision, right? We don't know what the jury used, what they mainly, depended on for that decision, right? Because no one's talked to the jurors yet. They haven't given out any indication of why, why they came out the way they did. But that, as far as the defense witness, that's the only thing really that they testified to, because Shake and Bake, if you're right, if they did it based on standard of care and that he didn't violate the standard of care, breach the standard of care, the civil cases have an enormous problem, because that's going to be a huge issue in the civil case, whether or not he violated his standard of care or breached the standard of care.
I think there's a potentially, and obviously I have no knowledge of this, but I would think one of the discussions that came up among the jurors would have been, how does this impact globally how we cope or deal with people at end-of-life situations? And jurors have a tendency to put themselves in the position of the victims, in this case, if you want to call them victims, or they put themselves in the position, even at times, of the person who's being charged with the crime. I think in this case, they probably thought to themselves, what if I was one of those individuals that had a end of life situation going on? Would I want to send a message to the other doctors that do this for a living, that provide this comfort care for a living, that every time they think about providing the comfort care, they have to consider, or at least acknowledge, that they may be charged criminally for murder? Because in this case, if that came out as a guilty verdict for murder, you can't think that if you're a doctor that provides this care, you wouldn't have puckered up a little bit and thought, geez, maybe I shouldn't do this anymore because I could go to prison. So I would think that maybe there was some discussion about, what do people want at the end of their life, which would be not to live their final moments in excruciating pain. But then if we say that this doctor is guilty of murder, what are we saying about every other doctor that provides this care? And will that somehow alter the course of this care to where it won't be as comforting, so to speak, for me or for one of my relatives or for my mom or my dad, or, and certainly something to consider, kind of the global ramifications of a guilty verdict.
And having to rely on the media reports, since I didn't listen to the testimony, I just know they were reporting it as he was giving these people like lethal doses of fentanyl. So allegedly that ties into the civil cases, because the nurses who were taking the orders, they were actually found guilty in civil court. And I believe the reason why is the doses that were being administered were so high that they said the nurses should have questioned it, and they didn't. So then that is what has everybody riled up on social media in the comments section when you read articles about this case, because they're saying, why would the nurses be held accountable, but the doctor who told them to do it gets off?
Well, I have a comparison for you.
Yeah.
What about the George Floyd incident, where you have, the cop who was ultimately found guilty of murdering George Floyd, but you had two other cops that were lower ranked, so to speak, watching this go on, and then them being charged for not taking direct action to stop it. It's similar in the sense that we've got this hierarchy of authority, and in a doctor-nurse-patient relationship, doctor is captain of the ship. So the nurse is, to some degree, short of maybe the doctor saying you need to go over there and stab that person with a IV needle. I think that's probably something that the nurse could say. I don't think I'm going to do that, but I'm sure there was a tremendous amount of pressure given that hierarchy of authority when the doctor gives you an order. I don't know that it's military in nature, but it's close.
I think that's why people are upset, because if you're the nurse in that position and the doctor is telling you to do something, do you really feel like you have the leg to stand on to speak out and question the doctor's orders without fear of losing your job? So I think people are kind of peeved that they're the only people who've been held accountable for it so far.
Well, I think people are conflating the issues. People are conflating the criminal cases and the civil cases, and that's a misunderstanding generally among the public about how those two things work. And Special K, you just mentioned that the nurses were found guilty in the civil cases. You're not found guilty in a civil case. You're found liable. They breached a duty and were found civilly liable for that breach and the harm that they caused. Okay. So Dr. Husel, yeah. Well, I'm just trying to point out that it's easy. It's easy to miss the distinction. Husel was found not guilty in a criminal court, and as Shake and Bake mentioned, a huge part of that was intent, the failure to maybe establish intent on behalf of the prosecutors. The civil cases are going to be a completely different matter, a completely different standard of proof. He still faces those cases right now. So he's still facing liability civilly, just like the nurses. The hospital system faced liability civilly and paid out millions of dollars in settlements already. They still face some liability for some of the families who didn't settle with them. So there is still liability out there for Dr. Husel. He's not getting off scot-free. On top of that, his medical license has already been revoked. Well, I think it's been suspended, not revoked, but his license has been suspended. And it's not likely he'll get his license back in the state of Ohio. He will certainly try to apply for it. I'm sure that's how he earns his living. But I think people need to realize that those are two completely separate systems: the criminal system and the civil system. So being found not guilty in the criminal system doesn't necessarily mean it's unfair treatment with the nurses. I'd like to point out the prosecutors have also noted they are not seeking any charges against any nurses or other staff outside of Dr. Husel. So they're not going to face criminal liability or criminal penalties for those actions that they were found liable for civilly. So I think those are important distinctions to make, because most of the comments that I hear out in social media and other places is that the failure to see that distinction.
That's what I thought too, that in a criminal case, you have to prove something beyond reasonable doubt. And in a civil case, it's only more likely than not. So it just would be a little easier to show the liability on the civil side. And then that's what happened with O.J. Simpson too. He was found not guilty criminally, but then I don't think he ever ended up paying that family, but he was found civilly.
How could he be found guilty? The glove didn't fit. Clearly couldn't have stabbed anybody. That glove wouldn't go on his hand.
LAPD is racist.
If you think about just a number of different cases over the years, especially high profile cases where people were found not guilty, not in all, but in many, there is a civil payout or there's a civil lawsuit that follows it where a substantial sum of money is paid regardless of the fact that the person walked in the criminal trial. And I attribute that to nothing short of overcharging. There's a way that the system adjusts accordingly to what the charge is, to what needs to be proven at that higher level of beyond a reasonable doubt. And if you overcharge, you risk what happened here, which is the person that you're alleging committed a criminal act walks with no record whatsoever because you got maybe a little too aggressive in the way that you charge the case. And prosecutors can make that adjustment or charge different types of crimes and then allow a jury to fit the facts within that set of crimes that seems more appropriate for that particular circumstance. Now, I don't know here if the indictment included lesser included offenses. I don't know the answer to that because I haven't followed this. I would guess that it did not if they got a straight not guilty, and I don't know the answer to that. Does anybody else know if there were lesser includeds like negligent homicide or manslaughter or any of those?
I don't know. But if you're being charged with both criminal and civil charges, do your criminal case always come first?
That just depends because, first of all, I think what you're saying is if you get charged criminally and then you get sued civilly at the same time, is that what you mean?
Yeah, in the case of OJ,
Gotcha.
or what's probably going to happen to this doctor, is there a rule that your
There's
criminal
not a rule,
case has
but
to be
there's
settled
certainly a
first?
better strategy. And we
Yeah,
have
my
that.
thought with asking that is if you're found not guilty beyond a reasonable doubt criminally, you could still make an argument that it's more likely than not that you did it civilly. But if you have a judgment that it's not more likely than not, would you be able to use that civil no liability judgment to help you in your criminal case? Saying like they couldn't even prove it was more likely than not. How are you going to prove it beyond all reasonable doubt?
Yeah, typically what would happen, and it's actually a case that we currently have at the Baker Law Group that we're looking into and we're investigating, but this happens on a number of cases that have a civil element to them that come into the office. There very well may be a corresponding criminal element. And the reason why a lot of times you want to see how the criminal case plays out is if the criminal case plays out and the person's found guilty at the criminal level, you've got a higher standard there. So now your necessity to prove liability is moot. I like that word, moot. In other words, it means that you no longer really need to prove the liability, because at a higher standard of proof, that's already been done. So there's nothing to come back and prove. The other thing that makes it more advantageous many times to wait until the criminal case is over is you may be able to, after the case is done, actually approach the prosecutor or the state or the feds or whoever has the information, and you'll be much, it's not a guarantee, but it's much easier at that point to get the information that they had, that they used in the criminal case to try to prosecute this individual. Prior to that, you're always going to get the same answer. The case is either under investigation or the case is pending a trial. We're not going to give out our discovery because that's all part of the strategy that they're using. They don't want that stuff leaking out that could taint a jury or whatever. With that said, though, it's always better to just wait and see, because you get a free pass on liability if there's a guilty conviction. There's another element to this, and that's the optics for the business, or optics for Mount Carmel. What do you do from a PR standpoint? Do you fight this and make a stink out of it and keep getting it in the news and bringing it up? Because that's obviously bad for business. Anytime you've got something like this going on with an employee, this would be a thing you would not like to have brought up on a regular basis if you want additional patients in your hospital. But with that said, how much of that was paid just as a publicity PR directive, or was it they paid it because they had enough information to know that the hammer was coming down and they just wanted to get it cleared out as fast as they could? I would never put as a third option that they felt morally wrong about finding a doctor that did this and they just felt so guilty they wanted to pay. That would not be a reason. I can be certain of that. Corporations don't have feelings.
I want to ask you guys about the other high-profile trial that's going on in the news right now. That's Johnny Depp and Amber Heard. He sued her for defamation for $50 million because she wrote an article in the Washington Post talking about how she was a victim of domestic violence, but she never actually named him. It was obvious when you read it that she was talking about him, but she didn't use his name. So he's suing her for $50 million and she's countersuing him for $100 million. So what does that mean when somebody sues you civilly and then you countersue them?
Essentially what happens, Johnny Depp has a claim against her, as you mentioned, for defamation. And I think that really stems also from the business that he lost as a result of the bad will associated with his name at that point.
Yeah, he definitely got fired from the Harry Potter stuff. So like he can definitely lost wages.
And Pirates of the Caribbean. I believe they were looking at more movies in that franchise as well that he is going to miss out on or missed out on already. So the parties that is suing, alleges their claims and whatnot, but the party that they're suing could also say, but wait a minute, you actually harmed me. I have claims against you as well. So they file a counterclaim against the party. Okay, so that's essentially what's happened here. She said, okay, you're saying I harmed you, but you've also harmed me. I don't know the basis of her suit. Is it defamation?
I just saw it reported as she was countersuing him. So I didn't know if that's what that meant. Like, you've defamed me for accusing me.
I don't know if her counterclaim is for defamation or not, but she's essentially turning it around and saying, okay, you're saying I injured you. Well, you injured me in some way, shape, or form, whatever it is. And anybody can do that. If somebody sues you, you could turn around and say, but wait a minute, you injured me as well. I have claims against you. So it's one of those where, Drew's got a problem with me, I've got a problem with him, but he sues me first. And I come back and I say, but wait a minute, I wanted to sue you too. I don't go file my own separate lawsuit. I file a counterclaim in the suit he filed. And we hammer all that out, we hash it all out in that case.
How does it work? Like if Johnny Depp loses, he automatically then has to pay her the 100 million, or
No,
do they come up with some sort of agreement, or can it
she
be like
still has to-
offsetting penalties?
She still has to prove her case. So they're both going to get an opportunity to prove their own cases. And just because he loses his case does not mean she wins her case.
Okay.
Okay, so they could
That's what
both
I
lose.
thought.
They could
Countersuit.
both lose. Yeah.
Okay.
There's something
So-
else really exciting called a cross claim.
Hmm.
And a cross claim, there's counterclaims and cross.
That's okay. Your head is going to explode.
Let's say that Matt tries to falsely imprison me in the office, or I think it's him, and he locks me in my personal office in the back. So I think I have a civil case for false imprisonment. And really, in the background, you were like coaching Matt, saying, you know, here's how you lock the door. Go ahead and do it. He said he was fine with it. He likes it. If, you know, he's stuck back there, he'll get some work done, actually, like whatever. And that's how it goes down. Well, I may counterclaim against Matt because Matt, I think, locked me in there. But Matt may cross claim against you and say, even though I had something to do with it, or may have had something to do with it, or was the one that did it, I think that Kelsey was telling me to do it and telling me you were okay with it. So she's actually at fault here. So I want to bring her into the lawsuit. I'm going to cross over and pick her up and bring her in as part of the person that I really should have directed my complaint at. I shouldn't have filed against Matt. I should have filed against you. So
And then
that's a cross.
Then I file my rebuttal, which is like snitches get stitches to Matt.
Yeah, you could counterclaim.
Not really good defense.
No.
On the streets it is. So
Oh, I got a lot of street experience.
me too.
So, well, cool. Yeah, that's the difference. Those were always confusing to me in law school. Cross claims and counterclaims, and like when you intervene, and all these. So you could intervene in a lawsuit if you think you have standing and an interest in the lawsuit, and you're not named as a party. You could intervene. That's on your own. You know, you would say, you'd motion the court and say, here are the reasons why I should be part of the party and I wasn't invited. So I want to be invited. So I'm going to intervene or ask the court to allow me to intervene into the action.
Well, I appreciate you guys for joining me on the Genuine Questions channel. This was a fun crossover. Thanks for answering
Thank
our
you.
genuine legal questions.
Yeah, thank you for having the SOL podcast on. We're happy to talk to all your listeners and our listeners about these issues. This is a big case, and it affects a lot of people here locally, and there are a lot of questions. We can tell by all the social media fire that's out there. So hopefully we're able to answer some questions that we've been seeing time and again on those comment boards. Great to be here with you.
Yeah, thanks, Kelsey. It was fun to be part of your show, and a lot less stressful on me not having to actually run cameras and audio and everything else. But I will say that if you have a case that you'd like us to have a look at, never forget to call the Baker Law Group. If you have an injury case, we'd be happy to take a look at it and see if there's something we can do to help you out and get you back to where you need to be and make sure you're properly compensated for all the troubles along the way.
You'll be able to find this on all the podcast apps and both Genuine Questions and the SOL Rumble and YouTube pages and wherever else we like to post. Yeah. So thank you guys. Have fun in Florida.